In 1964, a ship anchored off the English coast and started broadcasting. No license, no permission, just a position outside the law. 3 companies just filed for over 1 million compute satellites. No treaty can reject them on scale alone. The governance gap is filling fast. If your board has mapped where its data leaves New Zealand jurisdiction, what did it find?
Let's get into it.
In 1967, the nations of Earth signed the Outer Space Treaty. Every country agreed no nation may claim territory in space. No one wrote a clause about how many satellites one company may file. This is the Hamberger Report. I am Andreas Hamberger, AI governance practitioner, Wellington. The United States Federal Communications Commission is now holding applications for more than 1,139,000 orbital compute satellites. 3 companies filed them between January and June this year. The total number of operational satellites of every kind in orbit today, after 70 years of spaceflight, is approximately 10,000. The filed number is roughly 114 times the entire working population of objects in space. No treaty caps it, no statute caps it, no regulator anywhere holds a mandate to reject one of these applications on the single ground that it is too big. The governance gap is not ambiguous. It is specific, documented, and growing 1 month at a time. Every month these applications age to regulatory review is a month closer to the filed assets becoming a permanent fact. And the review process was never designed to answer a question at this scale. 3 companies filed for more than 1 million compute satellites between January and June this year. The FCC accepted every one. No regulator anywhere holds a mandate to reject a filing on the single ground that it is too big. SpaceX filed on the 30th of January for an orbital data center system up to 1 million solar-powered satellites between 500 and 2,000 kilometers up, each carrying onboard machine learning accelerators and optical links to its neighbors. SpaceX also asked the FCC to waive the standard deployment milestone requiring half a constellation to be flying within 6 years, citing the novel nature of the request. Blue Origin filed in March for Project Sunrise, 51,600 satellites in sun-synchronous orbit for in-space computing. And StarCloud, the company that ran Google's Gemini model on an NVIDIA Odd 100 chip in orbit last year, filed for 88,000. Each has been formally accepted by the FCC and entered into review. Then, on approximately 24 June, Amazon, Iridium, Globalstar, and Telesat formed Space Connect, a Washington trade body to coordinate positions on licensing, spectrum, and the next World Radio Communication Conference. SpaceX was not invited. Read structurally, the membership list is clear enough. Space Connect is a regulatory counterweight to a single dominant operator. In the 1960s, radio operators anchored ships in international waters and broadcast into national markets from outside any jurisdiction. They did not need to win a legal argument. They needed to be in place before the law arrived. The orbital compute filings are the same move at a different altitude, file at million satellite scale now, occupy the orbital slots and spectrum positions, and let the assets become harder to remove with every passing month. The mechanism is jurisdictional arbitrage, and it works because the governance gap is real and specific. Consider what is actually missing. The Outer Space Treaty assigns responsibility to launch states, but says nothing about data processing. The FCC's 5-year deorbit rule governs satellite disposal, not launch caps. The International Telecommunication Union coordinates spectrum, but does not limit how many satellites one applicant may fly. United Nations debris mitigation guidelines exist. They are voluntary. At no point in that stack is there a body that can look at an application for 1 million satellites and say no on the basis of size. If you want to understand the full AI accountability picture, Lethal by Design is running every Friday on this channel. Link in the description. The orbital environment already tracks 50,000 objects larger than 10 centimeters, and on the order of 140 million smaller fragments. Adding 1 million satellites raises the risk of a collision cascade no governance framework yet addresses. Why file at this scale at all? Because the economics on paper point upward. SpaceX has assembled the full vertical stack, its own silicon, its own model and compute, its own launch, and now an orbital data center constellation. This series has called this corporate Kardashev. The pull is the energy ceiling. Terrestrial data centers run into hard limits: cooling water, grid capacity, planning consent. Orbit sidesteps all three with near constant solar power and a vacuum as a heat sink. A Google research paper reported by CNBC in June put the threshold for orbital compute to compete with the ground at roughly $200 per kilogram to orbit by the mid-2030s. That figure rests on a single source chain and should be read as one analyst benchmark, not settled fact. Current rideshare launch costs sit far above it. The filed constellations are a scale-up of roughly 100,000 times the current production benchmark. New Zealand's ground-based space infrastructure regime covers the uplink and the downlink. It does not govern what happens aboard the satellite. Under the Outer Space Treaty, a United States-registered compute satellite processes data under United States federal law. The dependency question compounds it. New Zealand's infrastructure dependency on a single commercial entity now spans terrestrial cloud satellite connectivity and the lobbying architecture for orbital governance through Space Connect. That is the sovereignty exposure this series has traced through the Cloud Act and data residency, lifted one layer higher. The same orbital compute being filed commercially is what allied military and intelligence systems will increasingly rely on. A bipartisan United States Senate bill, the New Horizon Act, directs a pilot at the Pentagon's Defense Innovation Unit to evaluate commercial orbital data centers for military and intelligence operations and to study their resilience and vulnerability. Set that beside dedicated military constellations such as Starshield. When sovereign defense functions come to depend on processing owned by a handful of commercial operators under one jurisdiction, capability and dependency arrive together. For a country whose contribution is its ground segment and its allied data sharing arrangements, the structural question is not whether to use orbital compute. It is whose law governs the processing layer when the workload is overhead. 3 markers will tell you how this resolves. The World Radio Communication Conference in 2027 is the arena where spectrum coordination is decided. The NASA objection to Project Sunrise is the first formal governmental safety record in the docket. The second marker is the NASA objection to Project Sunrise, which sets the first formal governmental record of safety concern from inside the United States executive branch. It enters weight into a review process that has no authority to reject on scale alone. The third is the prototype launches, targeted for 2027. Watch whether the timeline holds, because the filings are a bet that occupation precedes regulation. If the prototypes fly on schedule, the assets will be in orbit before any framework is in place to answer the governance question. The pirates did not win an argument. They won a position, and the law arrived to find the facts already set. 1 million satellites have been filed for the machine. The governance question is not whether they should fly. It is whether anyone will decide the rules before the orbits fill. New Zealand has sensible ground segment legislation. It does not yet have a governance position on what happens in between. If your organization is evaluating orbital compute by 2028, here is the question your privacy officer will face. Where does the Privacy Act obligation sit when personal data is processed aboard a satellite registered in another country? Picture a technology director at a mid-sized New Zealand financial services firm reviewing a cloud strategy paper. One recommendation is to evaluate orbital compute from a United States provider by 2028 for latency-sensitive inference. She asks her privacy officer where the Privacy Act obligation sits if personal data is processed in orbit. He checks the Act, no provision for orbital processing. He checks the ground segment regime. It covers the uplink and downlink, not what happens in between. He checks the Outer Space Treaty. Processing aboard a United States registered satellite happens under United States law. The recommendation goes through. The workload migrates. Nobody has done anything wrong. There is simply no law yet that covers this. Executive takeaway: scale outrun the rules in 2026. jurisdiction ends at uplink. If you have found the point where your data leaves New Zealand jurisdiction, what did you decide to do? Leave your answer in the comments below, and I will see you next Monday.
That is the Hamburger Report for today. If this was useful, subscribe and hit the like button. It helps more professionals find the channel. You will find links to everything we covered in the description below. I am Andreas Hamberger, and I will see you tomorrow.
Like and subscribe.